Hello, everybody. Welcome to our webinar of today about digital nomads implications for employers. My name is Sophie Maes. I'm a partner at the Belgium member firm of Jus Laboris Kleijs en Engels, and it is my pleasure to host today's webinar. You may remember that in January, we already gave a webinar about satellite employees in which we discussed some key points that you must consider as an employer if you employ employees in a jurisdiction where you have no legal presence and where employees will permanently work remotely from their home. Today, we will do something quite similar, but still different, because today, as summer is coming up, we look at also employing employees in a jurisdiction where you have no legal presence, but where employees will only temporarily work because they do not have a fixed place of work, such as what we call the digital nomads, or because they just want to have an experience abroad and want to work sometime from abroad. All of this has become extremely important in the war for talents, that you can, as an employer, offer those opportunities to attract and to retain employees. But we are lawyers, and lawyers always want to focus on issues because now also these things comes with some legal and compliant issues, but we will also give you some solutions. And that is what we would like to focus on today. And what better way to do this with our lawyers from our main European summer holiday destinations. So I'm very happy to introduce today our panel, because we will follow a digital nomad who will work in the different places. So who do we have on board today? We go to Italy, where we will see Valeria Morosini, partner from our Italian member firm, Valeria. Our nomads will also visit Portugal with Ines from our Portuguese member firm, BBWR. Then we go to Spain with Anna and Paula from Sagardoi, and we will end our nice holiday destination with Dimitrios from Greece, from our member firm, Kremalis. So let's start our trip. And as always, the first thing we must consider is immigration, because of course, if you're not allowed to work somewhere, you can stop your trip. So that's the first thing we must think of. And the question then arises whether the employee needs to have authorization to work in our countries, or whether he needs a visa. And we have seen in the last months that their authorities are starting to react on the new trends, because in the pandemic, in a lot of countries, we have seen that they have introduced so-called digital nomad visas. Apparently, according to the internet, now there should be 41 countries that have already introduced such a visa. We do not know if it's true for all 41 countries, but we did at least a quick survey around our members. And to give you some examples, you see on the left side, the countries that have introduced, are at least some examples of countries that have introduced a digital nomad visa. And then on the other side, you see some countries which did not yet do so, and where you will need to find some solutions according to the more traditional immigration schemes that are available. But let's now start with Spain, because Anna and Paula, you told us in the preparations that Spain had recently, I think in December 2021, introduced the digital nomad visa, that it has been, or that it is now already extremely popular. So we would like to know what are the conditions, who can make use of it, who is using it, etc. So please give us some more light on this.
Thank you, Sophie. Hello, everyone. Yes, you're right. The visa for international teleworkers regulation came into force in Spain last December 2022. And from that moment, we have a visa and a permit available for international teleworkers. Our regulation covers both employees and freelancers. And the goal is to have here under international remote work two qualified professionals. So main requisites are that the digital nomad applying for the visa or the permit is a qualified worker holding an university degree or equivalent degree or equivalent experience, then the applicant must prove a seniority working for the company or the group abroad of at least the 3 months prior to the submission of the application. It is also very important that the company employing or hiring the employee or the freelancer has been running the business as at least 1 year. And then also to prove that the work can be conducted on remote. These are the key aspects of the requirements to qualify for the visa from an activity perspective. We also obviously have not being under any irregular stages in Spain, not having criminal records, being financially reliable. So in this regard, what they request is that while in Spain, the digital nomad receive at least twice minimum salary applicable in Spain. This is a very, very quiet news from today, because this is not regulated in the law. We just received 1 hour ago a new instructions. And the options we have for these digital nomads are 2. Either the worker can submit directly the residency visa application in the consulate having jurisdiction in his place of residency. Processing time is 10 working days and visa validity will be 1 year. And during the 60 days before the expiration date, once in Spain, can apply for the residency permit, which will have a validity up to 3 years and can be extended as much as needed. Or the other option will be directly to follow the in-country process. So the digital nomad can come to Spain as visitor, and once here under the allowed visitor period, he or she can apply directly for the residency permit for international remote workers. A key point that makes very attractive this visa is that dependents, a spouse, partner, children, minor children, and children of legal age, financially dependent on the principal, and who have not, who do not have their own family unit, can obtain a visa and a permit with same validity as a principal. And dependents of 16 years old can work in Spain. So it is really a very, very attractive visa category for foreign nationals, because a labor market test is not going to be taken into consideration, and requisites are quite flexible, and the process is very, very smooth, mainly because positive silent applies. This means that if authorities do not meet a statutory processing time, as I said, 10 working days for the visa and 20 working days for the residency permit, the application shall be understood as approved.
Thank you, Anna. So
Pleasure.
go to Italy. What's the situation there, Valeria?
Yes, in Italy, we are very proud. We also have legislation concerning digital nomads. So we are very, we feel very modern. Actually, we have only a little piece of legislation, and I will tell you more about it. But we're still waiting for additional information, additional decree providing details regarding the requirements and regarding the process. But what is this for? So digital nomads are meant to be non-EU citizens, possibly employees or contractors, working remotely through digital tools, and again, maybe employees of a foreign employer, so even not resident in Italy. So this is the scope. And again, we need more details from an additional decree detailing, for instance, among highly skilled employee, what do we need to consider? Or also, which are minimum salaries that would be required to apply for a digital nomad visa, etc., etc. So we still need information, especially regarding the process. But we can tell and we can say we do have digital nomads visa. What are the advantages of this? The first point, very important, is that a digital nomad would apply for a visa, and through the visa, they would get a residence permit for a year. So this means that first, they don't need to comply with the quotas. You know, the general principle for immigration from third countries is complying with maximum quotas. So they are outside the quotas, and also they can skip, let's say, the phase of the previous authorization to work, which is an additional step that normally applies in general and that they are not required to go through. So this is the advantage. What are the, again, requirements that we do already know? We only know that they need to have a health insurance that would cover all the risk throughout Italy. And also they would be required, listen, to comply with tax and social security. We don't know more about it. And so this is actually the key point, and we will discuss this later, probably concerning tax and social security. The point is we do not know whether there will be exceptions that would apply in terms of social security and tax. So we'll wait for additional implementation rules, but at least we can say we do have digital nomads.
Okay, thank you, Valeria. And Dimitrios, in Greece, you also have one, isn't it?
The digital nomad visa is also a new fruit in Greece that was introduced as of July 2022 with law 4825 of 21, and this was an attempt to enable third country citizens, both self-employed, freelancers or employees working remotely, again using digital technology, and means substituting their physical presence at the workplace, undertaking work for clients or employers outside Greece. And this is a very crucial fact that the law distinguishes. Another provision which is critical for the classification of digital nomads is their monthly earnings. They should be at least 3,500 euros, and they are subject to increase of 20% for the spouse and 15% for each child if the applicants include also the family members. There is a backdoor in the law enabling the ministry via ministerial decision to adjust these criteria, increasing or decreasing. And the idea of the digital nomads is actually to grant more flexibility to third country nationals, enabling them to enter the country for 1 year via the type D visa, and then issue the residence permit for up to 2 years, renewable every 2 years as long as the eligible criteria are met. This means that as long as the criteria, namely the income criteria, the status of the fixed term contract or indefinite term contract, or the project agreement remain as per the initial data provided, they can prolong their stay in Greece for a longer period. And of course, this raises some issues that we will discuss further on, but this appears to be a very flexible way of enabling the entry into the country for let's say a short-term period up to a long-term period, which makes it a rather attractive visa type.
Okay, thank you, Dimitrios. And then at the end, Ines, Portugal.
Hello, thank you, Sophie. Hi, everyone. In Portugal, there is also a very famous digital nomad visa, which has been in the news all over. And the law has been passed in August 22. but the additional ruling to the law. So until then, we only had from August to October, we only have had something like in Italy, like a piece of legislation allowing theoretically individuals to apply to digital nomad visa. The law was then ruled further in October 22, and it has set some criteria which are not that different from what all of you have been saying. So the beneficiary of the activity of the digital nomad may be either an individual or a company. It must be located outside of Portuguese territory, and the person applying for the visa can either be an employee or a self-employed. So, of course, when applying, the situation either being an employment relation or a services agreement has to be proven. The person must also, similarly to Greece and to Spain also, it has to show that they have an average income of a certain amount. So the amount is now 4 times the minimum national wage. So the applicant needs to prove that in the preceding 3-month period, he or she has had an average income of 3,040 euros to be able to be considered for the digital nomad visa. The digital nomad visa allows 2 entries in Portugal and a maximum stay of 4 months, after which the person has to apply for a work visa, a residence permit, which is how it is called now, which will be valid for 2 years and can be renewed subsequently for periods of 3 years. There is no maximum limitation. Of course, that after a certain period, the person may be able to apply for a permanent residence, but there is no actual limitation in applying, continuing to apply for a digital nomad visa, as long as the requirements are still met.
Okay, thank you, Ines. But just to be sure, Ines already highlighted it. It's both for employees and self-employed, but that goes for everybody, yeah? All right, okay, thanks. I know there were a lot of conditions, but Isadora, can you just click on the next slides? What we have done in the slide is try to summarize all of these conditions in this slide. You will find it on the package that you will find on our website. So that was immigration, but of course there is more than immigration. We already heard it in the conditions. There are other things as well. So let's talk about perhaps now a bit about Social Security. What happens in terms of Social Security? Do we need to pay local Social Security, or can we remain on the home country Social Security? Dimitrios, what happens in Greece? What's the position there regarding Social Security?
Thank you, Sophie. The situation in Greece is rather tricky with regards to Social Security, because there's no clear legislative framework providing for the Social Security treatment of digital nomads. So what applies is that there should be healthcare insurance coverage, as in other countries throughout the Greek territory. Nevertheless, then Social Security coverage, the payment of the respective Social Security contributions will be done at the country of origin. There have been some discussions whether this should be changed, especially taking into consideration a longer term digital visa nomad, which would imply issuing a national Social Security number, being registered at the National Social Security Institution. But so far, this is being maintained within discussion among scholars and among legal practitioners. And of course, such change would impact the timelines, the processing timelines, and the mobility. So at the moment, and as far as the situation remains unchanged, there is no clarity, and one should ensure the coverage in the country of origin.
Okay, thank you. And Valeria, you already gave us some idea about it. So what's the position in Italy?
Yeah, the point, as I said, is that we have one provisions that said nomads need to comply with Social Security, which means that so far we don't have a special exception concerning Social Security. It may come, but we don't have it yet, which means, again, that we need to apply general rules. So if we consider non-EU citizens, that means that we need to look at the treaties between Italy and the different countries, home countries of those employees. And I can say that very often in those treaties, we have exceptions. So provisions according to which Social Security can be maintained in the country of origin and therefore skipped in Italy. So first point is that we need to look into those treaties. If such an exception is not provided for, then it means that Social Security should be paid in Italy as long as work is carried out in Italy. And this means that if the employer is a foreign employer with no presence in Italy, they need to set up a Social Security representative. So I would say, if there is no special rule coming up in Italy soon, and if the treaty doesn't provide for exceptions for nomads or something that could be applicable to the nomads, then it would be quite a harder to pay Social Security. And so it would really be a matter of establishing how long employees is going to stay. But we will look into this quite early. If we look into EU regulations instead, we know there are situations in which exceptions are possible. So we know the A1 form. And of course, given the fact that probably in Italy, this would not, because a digital nomad is not going to be considered a posted worker, but still, if the country of origin is going to issue an A1, actually the Italian authorities would need to stick to it and accept the fact that Social Security is not going to be paid in Italy.
Okay, thank you. And Anna or Paula, what about Spain?
Thank you so much, Sophie. So in Spain, we have a very similar situation. We apply lex loci laboris principle, which means that every worker who works in Spain must pay the Social Security quotations in Spain. However, we have some bilateral agreements as well as EU directives confirming that with an A1 certificate or a certificate of coverage can apply this exception to this principle and can remain paying the quotations on the home country of the employers. However, with the A1 documents, we have seen that not all the EU countries are applying this exception for international workers scenarios. As well, the bilateral agreements that Spain has signed with the rest of the countries, which are non-EU countries, do not specifically include this scenario either. So according to the instructions that we have received from the Spanish Social Security authorities, they will apply this type of bilateral agreement as far as the other country, as the other party agrees to apply this exception, even it is not specifically included on the bilateral agreement on the text. We have seen that some non-EU countries are issuing the certificate of coverage for this type of scenarios, but we cannot confirm 100% that it will be the usual scenario. As on Greece, as Dimitri commented, nor or almost none of the bilateral agreement includes health insurance. So a health insurance will be also required. In the worst case scenario, that means in the event that the Social Security certificates can be issued, nor the A1 document can be either issued, or if they have been issued, but they have been expired and they cannot be renewed, local quotations must be satisfied in Spain. For international remote workers, the home entity must be registered in Spain as a non-resident foreign entity, request a contribution, count a code, and pay locally the quotation for the international remote worker in Spain. So this is the main important point, because even we have this certificate of coverage, this A1 certificate, and at the end of the day, this is expired and it cannot be renewed again, or if it cannot be issued from the beginning, local quotations must be satisfied in Spain. And the only way that these quotations can be satisfied in Spain, as mentioned, is that the home entity must be registered in Spain as a non-resident foreign entity and pay the quotations by using the contributions account code.
Okay, thank you very much. And then in Portugal, do we need to pay there as well?
That's a good question. The law did not set any rule specifically for the digital nomads, so the general rules apply. The general rule says that you have to pay your Social Security contributions where you work. So on a first analysis, the response would be that the digital nomad would have to pay contributions in Portugal, Social Security contributions in Portugal. Similarly to Spain, of course, being the employer and not talking specifically about employees and not the self-employed, the employer not being a resident and not having any locally incorporated company in Portugal would, of course, have to register as a non-resident entity, similarly to what Paula was explaining, to allow the payment of contributions in Portugal. Another situation that also applies in Portugal fully is, of course, the Social Security treaties, like Valeria was mentioning, and Dimitrios. It's the same. Portugal has a significant number of Social Security treaties executed with other countries, be it EU and non-EU, and of course they will fully apply. There is, of course, a big question mark on whether secondment rules would apply to this. We would say probably not, because this is really not a secondment, but depending on the duration of the stay that is intended by the digital nomad, of course, if the home country, like Valeria was saying, if the home country issues an A1, even if Portuguese Social Security does not agree to that, they will not be able to refuse it. And in that case, of course, the digital nomad would continue to pay Social Security contributions in the home country. So, but it's still to be seen. To be on the safe side, we would recommend Social Security contributions to be paid in Portugal.
Okay, thank you very much. Just that you know, Belgium's issue A1 form for secondments in those cases. So let's move to another topic, employment rights, because typically digital nomads, especially if they work there for a short period of time, they remain employed under their home country employment contracts. But then the question also comes up, can they also invoke local employment rights, and do employers need to comply with local employment conditions? And if so, is that immediately or only after a certain period of time? So perhaps Valeria, can you give us a bit more insight?
Yeah. And also I think it is a very important point, and it is even more important because this is already answering a question that came up. A question in the Q&A asking whether or not the employees need to be on a local contract while working as digital nomad, and does the employer need to adhere to local labor legislation? So this is precisely the point. And again, it is very important because if you say, have an employee coming to Italy and stay in Italy, and this means that you need to apply entire Italian employment legislation, I mean, this is something you need to consider in advance. So the point is, again, we go back to this point, which is probably in Italy, a digital nomad would not be considered a posted employee, because posted employees are considered those who are sent to a country by their employers, while we assume a digital nomad is someone choosing to come to a country and probably moving based on their own personal choice. So I would assume that the special regulation applying for posted workers wouldn't apply. And therefore, we need to go back to the general rules, so Rome 1. What do they say? First point, very important, is that the choice made by the parties regarding applicable law is valid and is important. So let's take an employee coming from the US with under, and this is again answering the question, under a US employment contract governed by US law, that choice of US law is valid. But of course, you need to consider that this choice cannot deprive the employee of the protection that would come from the law of the place where the work is carried out, of the place where the work is habitually carried out, to be precise. So the point becomes, where is the work habitually carried out, especially in the case of a digital nomad? So I would assume that digital nomads, again, would travel around the world, would move around across Europe, across different countries. So we assume that the stay, in our case, in Italy, would be temporary. But because the definition of habitual place of work is quite fluid, we have a lot, of course, of definitions coming from the decisions of the court and the Court of Justice, but it is quite flexible in the way that I'm gonna explain. So habitual place of work is meant to be the place where or from where the essential part of the duties is carried out. And therefore, it's not something that you would decide in theory, but it's something that would be decided on a factual basis. And the judge, if a judge was requested to decide whether or not Italian law would apply, when they need to decide whether Italy is or not the habitual place of work, they would probably look at the entire employment relationship, the entire employment contract. And therefore, as long as the employee started from a country and then came to Italy, stayed for a while, and then moved back, and especially at the end of the all traveling, they go back to the home country, I think there would be good arguments to say Italy is not the habitual place of work. Italy is a temporary place of work. But of course, as long as the length, of course, is very extended, but also, for instance, the employee is leaving the US and coming immediately to Italy and staying in Italy for a year, and then the employment contract is terminated. As a matter of fact, Italy would be probably the only place of work for this employment contract. So there would be a risk that employment legislation would apply. So I think it's very important to look at the overall relationship. And as an employer, of course, if you have employees going around traveling as nomads, I think you would need to try to have some control, at least on the length of their stay, and also on whether they would go back to the home country in the end. So again, to finish the answer to the question, you do not have to establish a local contract, at least, so you do not need the employee to have a local contract, but this doesn't mean that you are not required to apply Italian legislation, depending on whether Italy can be considered the habitual place of work.
Okay, thank you, Valeria. And Ines, in Portugal, is that the same analysis, or do you have some other things that...
I would say I tend to agree with Valeria. Of course, since there is technically no secondment to Portugal in this case, Rome 1 would apply. So the parties are indeed free to choose the employment law that would apply to them, provided that, of course, the parties that are, or the parts that are mandatory and unwaivable rights of the employee would be respected. Although the secondment framework is not directly applicable to this situation, we do have a general minimum mandatory framework that applies to secondments and that gives you the elements of Portuguese law that cannot be waived by the parties. And although it is not directly applicable to this situation, it gives you a good framework of the parts that you should be very careful when waiving, if you are in fact waiving. So using the example as Valeria was putting of having someone coming from the US, where you can have free dismissals, if the person is freely dismissed by the US company while being in Portugal, even if the person has been here solely for 3 or 4 months, I would tend to say that judges, if it would be claimed in court, would tend to consider that Portuguese law would apply, even if the duration of the whole employment bond would be much shorter in Portugal than it had been in the US. So this is, of course, something that employers need to be very careful when hiring or when accepting a digital nomad to work from Portugal, as they already do when a secondment is at stake. So I would say that to be on the safe side, the same rules that apply to secondments should apply in this case.
Okay, thank you, Portugal. And what about Greece?
Thank you, Sophie. There seems to be a consensus, at least among Greece, Portugal, and I think also Spain, that we should respect the local mandatory requirements, establishing minimum provisions while applying the employment of digital nomads. And of course, as Valeria highlighted, the issue of the habituality is very significant as to the interpretation of the contract. But in any case, in the example illustrated of the US employee employed in Greece, there would be the US norms applicable while maintaining the minimum standards on annual leave and rights, on occupational health and safety, on equal treatment provisions. So the main issue that one employer should consider when employing employees in Greece via the digital nomad status would be to ensure that in case of a potential inspection by the labor inspectorate, he would be able to justify that the work rendered, the services provided, would be towards the foreign entity and not, for example, a certain addressee within Greece or have any ties with an employer in Greece. And this, of course, relates to the question whether an employer of record would be a feasible model to occupy employees. This would be rejected in any case for Greece.
Okay, thank you. And then Spain, is the analysis the same?
It's very similar. However, in Spain, we have been confirmed that we need to separate very well both the scenarios, which is a posting directive and which is international remote worker scenario. So in this case, posting directive will not apply for the international remote workers in Spain in any of the cases. So they should not respect the minimum holidays and etc., etc. However, from an immigration perspective, as Anna mentioned, we have received 1 hour ago, approximately, the official instructions on how this will apply. And for this type of applications, they are requesting that the international remote worker confirms that he or she has an economical means such the double of the minimum salary applicable in Spain, which in this moment is around 31,000 euros per year. So in order to apply for this type of visa or residence permit application, international remote worker must have at least a salary of 31,000 euros per year.
Okay, thank you. And I thought, Valeria, you wanted to add something more.
No, it was just to add something, just to keep it simple, but specify one thing is the applicable law that I described earlier. So whether Italy is the habitual place of work, in that case, the entire employment legislation would apply. Another thing is in cases where Italian law would not apply, but there would be mandatory overriding legislation provisions that may apply, which is not the entire employment legislation. It's only, let's say, the rules, the Italian rules that are linked to our fundamental principles as stated in the Italian constitution. And therefore, I would say all those who are related to health and safety of the employees and things like that. So whenever the law applies, that's fine. It's going to be the entire Italian employment legislation. When it does not apply, there may be still room for mandatory overriding provisions and also public order. And the reason why I mentioned this is because we made examples about the US, and most part of the decisions that we have in Italy about applicable legislation are in cases where the US are involved. And this is because legislation is so different and dismissal is at will that very often employees try to, ask for the application of Italian, at least public order, through the concept of public order and through the concept of mandatory overriding provisions.
Okay, thank you. And then last but not least, but also very important, taxes. Has the digital nomad, does he have to pay taxes in the host country? Ines, what is the position in Portugal? And then also, does it mean that we have withholding obligations as employers? And also, what about permanent establishment risks?
Thank you, Sophie. There is a question, there is an open question on the Q&A. That is precisely that, will the employer be taxed in the host country? The answer is, of course, it depends. So for the employee or for the individual, the person will be paying taxes in Portugal if he or she is considered to be a tax resident in the country. To be considered a tax resident, the person has to stay in the country for at least 183 days in any given 12-month period, or hold a house, a flat, either rented or bought, that allows the tax authorities to understand that the person wants to use that place as their habitual home place. So with either of these, if either of these criteria are met, the person is considered a tax resident in Portugal, and in that case, the person will have to pay personal income tax in Portugal for the worldwide income and not only for the income received in Portugal. So this is on the employee or the individual side. On the employer, answering the question of one of our attendees and your question too, Sophie, the employer may have to pay corporate income tax in Portugal for the income generated by the individual activity if it is understood that there is a permanent establishment of the company in Portugal. So to have the permanent establishment existence is not something that you can say yes or no, just like that. So what I'm trying to say is, it's not only the fact that you have one person working in Portugal for you being a company outside of the country, that will automatically generate the risk of a permanent establishment. That risk will need to be assessed on a case-by-case basis, and various elements will be taken into consideration. First of all, the fundamental one is if the employer has any premises either bought or leased in Portugal, be it an office space in a co-work office or warehouse or whatever. So if there are any company premises from where the employee is performing their work. Another very important issue is whether any storage of company goods is taking place here in the country. That would also be an additional factor of risk. Another one is if the employee is pursuing any core activities of the company. One thing is to be a software developer for a company that is not a software development company, so it's an accessory role. Another thing is to be a software developer, for example, in a company that precisely sells software. Okay, so the core activity that the employee is, the activity that the employee is performing, be it core or non-core, is also a topic or an item that will be assessed when evaluating the risk of the existence of a permanent establishment. Even if there are no premises in the country, of course, we know digital nomads most likely will be working from home. The existence of a home office will also be analyzed under this criteria, whether it is used for storage, whether the business that is being carried by the individual is core or non-core, and also very importantly, if the person has binding powers, if the person has a power of attorney, a proxy, and if the person has the powers to act on behalf of the company in the sense that they have powers to conclude contracts, on behalf of the company without the intervention of the home company. So if they are autonomous in managing the business, that will be a very important factor to be taken into consideration. A key topic or a key hint that we would like to leave is that it is very important to look at the individual's job description, because many times we think the person is coming to the country to do a certain thing, and when you look at the job description, they are doing a totally different thing, or they are doing that plus 10 other things. And of course, the tax authorities will always try to get taxes to be paid locally for obvious reasons. So the employers must be very, very careful when designing the role of the digital nomads in case they want to avoid that risk, or at least to limit it to its lowest degree possible.
Okay, thank you, Ines. Valeria, what about Italy?
I can make a quick comment. One, to say that I couldn't agree more to the analysis provided by Ines. So this is very much also the approach that we take to assess the risk of permanent establishment in Italy. Otherwise, I would say, again, the provision we have states that digital nomads need to comply with tax regulations, but we do not have the details yet, so we don't know whether there will be exceptions that need to be taken into account. Another point that comes up from the first comments from the authors, etc., is that probably digital nomads, whenever they become tax resident in Italy, they could benefit from the special regime that is applicable to impatriated employees. Of course, there are requirements to be met in terms of how long you need to have been outside Italy, how long you are going to stay in Italy. But let's say that probably they would be, they could access this special regime that is more favorable in Italy. So this is something interesting for them.
Okay, thank you. What about Greece?
In Greece, we have similar rules applicable, like in Italy and in Portugal. Namely, it is crucial to assess whether the employee is indeed rendering supportive or ancillary services, or hidden acting within the organization in order for the employer of origin to avoid the local setup. And I have to say that Greek authorities are rather aggressive when assessing whether there is a permanent establishment or not. So they tend to impose fines in cases where they are rather ambiguous or in the gray zone, and then the employer has to question and enter litigation to showcase that there was not a permanent establishment. So it should be really careful when assessing, again, the job description and the scope of services. And of course, clearly elaborating that the framework that is set for the sending of the employee is maintained and not amended in a way that would increase the permanent establishment risk. Recently, there have been some changes making more attractive change of residency for foreigners in order to acquire the Greek tax residency. And there was a discussion and actually a lot of controversy in the web. If one makes research on digital nomads in Greece, he would find out that they can benefit from tax deductions, that they can have a lot of glooming tax treatment, which is actually not the case, because if one wants to change the tax residency, one has to ensure that he does not render services to foreign entities, but to Greek legal entities. And as illustrated before, this is inconsistent with the notion of digital nomads. In any case, there is a lot of room to assess whether the 183 days principle is prevailing, or whether what happens in case of consistent renewals of the resident permits. And we are expecting some presidential decrees to clarify this.
Okay, thank you. And then last one, Spain, a quick one, looking at the time.
Quite similar. I mean, the aspect to be considered to determine if there is a risk of permanent establishment or not are quite similar. And from a personal perspective, from the worker perspective, as a general rule, after 183 days in Spain, the digital nomad will be considered as tax resident in the country unless, according to applicable international tax treaty, signed with his residency or home nationality country, states differently. So always very important to review this international tax agreement to see if for any reason they can be exempt to be considered as tax residents in Spain. Now, once they are considered tax residents in Spain, as in the other countries, they might benefit from the impatriates regime, which means that they are going to be taxed as non-residents, meaning that the earnings coming from employment, from work activities, up to 600,000 euro will be taxed at 24% instead of 88%. And the amount exceeding this 600,000 euro will be taxed at 48%. So it is very important they know that this regime exists and that there are 6 months to apply for it from starting the activity in Spain while they are considered as tax residents.
Okay.
And nothing more to add.
Okay, I'm still
Thank you.
Very, very quickly, a last question, because we have a lot of questions also from the audience, which I would like to address as well. But very quick, based on your experiences, if somebody wants to share, what would be your recommendations to give to handle digital nomads? What do you see also in your practices in terms of timings, countries, etc., etc.? Valeria, if you have some insights on that, recommendations.
Yeah, I have a preliminary conclusion, a preliminary takeaway. I think we all understand, and what we can understand here is that there are a lot of compliance issues here. So my point is, I believe you may want to have the situation under control, and at least you want to be conscious of the risks that you are taking. So the solution that many clients I see are adopting is to have a policy in place. A policy is just to establish some minimum rules concerning, for instance, the length of the stay for digital nomads, or for instance, the need for an authorization whenever they need to travel abroad and work from abroad. The point is precisely to put some limits and be aware of whether you're running risks or not.
Okay, thank you. Anyone else something to add, or shall we pass? I see we have 5 minutes for questions.
No, from our side, just to add that we do consider it is key to have a holistic approach to the digital nomad scenario. It's not only about immigration. In Spain, we have a great solution for immigration, but it's all about also tax, social security, employment, health and security perspective, and not only from the employee, from the foreign national, but also for the foreign employer. And always very important, I guess, in Spain, but also in other jurisdictions, to respect the limits of the visas and permits for digital nomads. I mean, there are very, very strict permits as a general rule in terms of allowing just to work for companies located abroad and not for companies located in the host country, the case of Spain, the freelancer can work 20% of his time or activity for local clients. But as a general rule, these visa categories has very, very clear rules that must be followed.
Sophie, if I can add something very quickly, another takeaway that I would like to add is that because of insurance coverage, and there are certain countries, including Portugal, that have certain mandatory insurances that need to be hired, you should have policies in place to make sure that your employees are covered, even covered by those insurances, even if they are working from abroad.
Another aspect, Sophie, also to consider is that in Greece, because of the quick processing times to issue the digital nomads visa and to enable third country nationals to enter the country, we have experienced certain cases where employers tried to take advantage of this kind of visa by not, let's say, fully complying or by getting into the gray zone, which means entailing a significant risks. For example, if an employer would start with one individual as a digital nomad and then hiring another 3 individuals to assist him and rent a common conference room, this is something that for sure would signal to the authorities and should be avoided.
Okay, thank you. We still have a few minutes. I suggest we look at some questions from the audience. Perhaps I see a question about the maximum validity, but actually that is on the slide. So if you go to the slide in the chart, you find there for each of the countries the maximum validity. But I see another quite interesting question. It's a long one, so I will read it. So where there is an explicit requirement that the worker works for an entity outside of the country that granted the digital nomad visa, what is the interpretation where there is a group of companies? For example, an employee works for the entity in Portugal, but wants to work in Greece under a digital nomad visa. The employer has an entity in Greece, but the employee will continue to be an employee of the Portuguese entity. Would this cause an issue? Because I think that's an important question, because we very often see that in groups where there is a lot of movement between the groups. Valeria, I see you.
Yeah, I want to make a quick comment. It's not really an answer, but this question is very interesting to me because I was quite surprised, and I'm talking about Italy here, of course, because in the law ruling digital nomads, they say digital nomads can work for companies even not resident in Italy. That means, in my view, in my interpretation, that can also be in Italy. So we always consider, and I think this is the perspective for Spain, as Anna was saying, that digital nomad would be working for a foreign employer. And I also would expect this would be the most common situation. But I think, especially for Italy, as long as there is a mention of an employer, even possibly being in Italy, we need to confirm this, and we also need to see what the authorities say. But otherwise, that would be an interesting additional channel for Italian employers. So, of course, the current comments say even Italian employers may use digital nomads as long as they work remotely, which sounds very funny to me, because it means I'm an Italian employer, you are my employee, but you shouldn't come to the office because you're a digital nomad. I don't know. So we'll need to get more interpretation on this, but I think this is a very, very interesting question, because at least for Italy, we need to confirm, explore and confirm, but it can be an interesting opportunity also for Italian employers. And I think in this way, we're also answering the question, the second question, that was whether digital visa only must be used by companies who do not have an entity in the country. So at this stage, I would say for Italy, possibly there would be the chance for Italian employers to use digital nomads. We'll see.
In Portugal, if I can add to that, it will not be possible. So the digital nomad is foreseen specifically for entities who have a head office or are located outside of the Portuguese territory. So in this specific case, if it was the other way around, so the employee being a Greek, an employee from the Greek entity coming to Portugal, if the Greek entity would still be the employer, he or she would be able to apply for a digital nomad visa. So there is no mandatory rule that says that because it's a group company, the person has to work for the local entity. So he or she would still be employed by the Greek entity and would apply for a digital nomad visa to work in Portugal for that entity. But nonetheless, I would like also to add that there is a specific visa in Portugal for intra-group transfers. So employees who are being transferred from one group company to another one, they can apply to a specific visa. So they do not need to follow this procedure for the digital nomads.
Thank you, Ines, because you answered it also for Greece. Actually, one would apply the ICT visa in this case instead of a digital nomad visa, which would entail more problems as to whether the group is regarded as an employer, as a foreign employer. And this leaves much room for interpretation depending on the actual circumstances, the use of search services. So I would suggest in the particular example to use the ICT visa.
Okay, thank you very much. And sorry to interrupt you, but I'm looking at the time and I get instructions that I have to wrap up. So I thank you all very much for attending, but perhaps I also saw a last question about employers of record, and that allows me to go, Isa, if you can just show the next slide. Because actually we are part of an expert group, Immigration and Global Mobility, and we did a lot of things and surveys around global mobility issues, or topics, not issues, topics that you can find on our website. For example, every 2 months, we issue an update on recent developments in immigration and global mobility. The new one will be there next week, so it's being prepared as we speak. But what is interesting to respond to the question is that we also did a survey on whether in countries employers of records are allowed. And as you can see, the answer is not everywhere the same. So I invite you to go to our website and to have a look at our map. And I think that's the way I want to end it here. So I thank you very much for attending. Also, a very big thank you to our panel. I'm still trying to figure out in which country I would like to go this summer, but because in Belgium it's very often raining. So thank you for all the insights, and also for the audience. I hope you find it very interesting, and I wish you a pleasant further rest of your day. Thank you.